Welcome to Employment Law This Week. I'm George Whipple. Our top story, New York City announces new guidance for pregnant workers. Mayor de Blasio and the Human Rights Commission have released new guidance that defines pregnancy protections under the city's human rights law. The publication gives examples of accommodations that should be made by employers and outlines what an employer must prove if denying an accommodation. Nancy Gunzenhauser has more.
New York City has a very broad mandate when it comes to discrimination and harassment types of claims. And so these legal enforcement guidance documents seem to be providing what is the Commission's interpretation of how far employers should be going in order to uphold these rights. It's really important from these guidelines to document the entire process. And at the end, if an accommodation is found, that needs to be put in writing and provided to the employee. Just as importantly, if an accommodation is not found, then the employer should document that to show that they've gone through this cooperative dialogue.
The Ninth Circuit reaffirms employer time rounding. A call center employee in California recently brought a class action against his employer for time rounding practices. The employee claims that the policy caused him to be underpaid by a total of $15 over 13 months. Relying on a California Court of Appeals precedent, the Ninth Circuit found that the company's facially neutral rounding policy, one that rounds time both up and down, is legal under California law. The employee also argued that he was denied payment for a total of 1 minute when he logged into call software before he clocked in. The court found the de minimis doctrine applied in this case because identifying a single instance in order to provide payment would create an undue burden on the employer. A Virginia-based tech firm settles with the EEOC on transgender discrimination. An employee of technology services company Ellucian was working on-site at a college campus when she told coworkers that she planned to transition from male to female. The employee was barred from work the next day. An EEOC investigation revealed that the college had asked the company to remove the employee from campus, and Ellucian complied. The company has agreed to pay $140,000 to settle the complaint. Ellucian will also change its employee code of conduct to prohibit discrimination based on gender identity. More from the EEOC this week. The agency can now move forward with an English proficiency suit against Wisconsin Plastics, Inc. In 2014, the EEOC filed a lawsuit against the company for firing 22 Hmong and Hispanic workers who were not proficient in English. A U.S. district judge in Wisconsin denied the motion for summary judgment, ruling that a jury could reasonably find that the terminations were the result of national origin discrimination. While language proficiency might be required for some jobs, the judge found that Wisconsin Plastics hadn't provided sufficient evidence that this was the case for the jobs in question. And that brings us to our tip of the week. Here's Kristen O'Connor with some advice on building a strong relationship between legal and IT.
Collaborate on drafting the policies and procedures and refining those policies and procedures that are going to govern your company's data management. Communicate both with your internal IT resources and with external vendors that you use to help with processing information and also for litigation support. The third tip for counsel for fostering a strong relationship between legal and IT is to keep IT informed. As the legal department, you are the gatekeepers of all of the changes, whether they're legal changes or regulatory changes that will impact how your company does business.
Thanks, Kristen. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.